Today is November 15th or 13th, 2025 at 7 o'clock. Can we all stand for the Pledge of Allegiance, please? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So, oh, yeah, I think he is.
You have to read the.
So obviously, I'm filling in for Megan. If she couldn't be here, please go ahead and call roll.
You have to read why we're here first.
Okay, the purpose of the special meeting has been called by Trustee Rosso, Parker, and Fowler for Thursday, this day, November 13th, 2025, at 7 p.m. The purpose of this meeting is for the Village Council to review the ZBA's status and actions to determine if they are illegally operating within the perimeters of the Village of Romeo zoning ordinance. Ordinance 482 adopted on July 17, 2000. Article 18 and 18.00-18.06 of Ordinance 842, online reference division 4611.2 and 4671, 46-77. Specifically deals with the Zoning Board of Appeals and is the focus of this meeting. Get an approval of the agenda?
Roll call. Oh, roll call.
Oh, roll call, I'm sorry.
Rossa,
Here.
Parker,
Present.
Fowler.
Yes.
Here.
Here.
President Pro Tem Bartholomew.
Here.
We have a quorum.
Okay, can we get approval of the agenda?
Motion to approve the agenda.
Second.
So motion by Parker and a second by Fowler. Okay, is there any, what's that? All in favor? Aye. Okay, so public comment, is there anyone that'd like to get up and speak? You got 3 minutes. Just state your name and address and.
Danielle Lee, 171 Tilson. I respectfully request that none of the trustees accept any meeting pay for tonight's session. It is deeply troubling that a trustee would use their position of authority and taxpayer dollars to pursue a personal interest. This situation is not worthy of a special meeting, especially when a regular meeting is already scheduled for Monday. Given the financial state of our village, it is shameful to spend taxpayer money on a special meeting for an issue that clearly does not justify it. It is equally concerning that a trustee would vote on a matter in which they have a personal stake and then attempt to reverse the outcome using additional taxpayer resources simply because the vote did not go their way. You can offer explanations about meeting timelines, the legality of ZBA actions, but we all understand what's actually happening here. Please focus your efforts on what truly matters, repairing our roads, and developing a plan to address the critical infrastructure needs of this village. Stop diverting attention to what other boards are doing and start addressing what your own board is failing to do. The taxpayers deserve better.
Thank you. Anyone else? Okay, moving on to number 4, new business. ZBA Ordinance.
So thank you all for coming tonight. In your packet is the ZBA Ordinance pages that we're going to focus on. I appreciate everybody's time and energy, and I'm not sure if everybody knows that I am currently on the ZBA. My term will finish in January, but we had lots of changes recently, and at our last meeting that was called, some of those changes became apparent that I wasn't necessarily aware of until we got to the meeting. So as we conducted the meeting, I'm fairly certain we're not operating within the parameters, and I'm concerned about the village in and of itself and making sure that we're doing what we need to be doing. So there were 3 of us present. That's all we have on the ZBA right now. And when we arrived, we didn't have a chairperson because our previous chair had moved on. So there were 3. We needed to elect a chair and then conduct business. We did have a secretary. Sarah was there, and I opted to start the meeting, got us to the point of nominating a chair, and then passed it to the chair. We conducted business, we took our votes, and the evening was done. But I knew in my mind that we had specific numbers we had to meet. I wasn't quite sure at the moment. I had faith that we were all called together to get this job done. But when I look back, just to confirm, okay, you know, what should we be doing, how are we doing it, we are not in following our ordinance in accordance. Our ordinance says we have 5 people with 2 alternates. And then it says we have to have 4 concurring votes, but we only have 3 people on the board. Part of my concern is we've had 2 business owners do business with us, and in the future, we're gonna have to have this resolved before, I believe, we have any more meetings, because we're not operating. And that's why I asked for Mark Clark for his professional opinion of, you know, how do we monitor this? Are we okay with what happened? Is the meeting valid?
Was the meeting posted?
Yes.
The village?
The meeting was posted, and it was posted
On the
saying that there was going to be a public hearing as well. But when we started the meeting, I was remiss. I said, okay, I will start the meeting. I did not call public hearing.
So there was no
I
public
would-
hearing?
No.
And it was posted
I
on
would
it?
write to the agenda a little bit discombobulated, because I wasn't expecting to not have a chairperson or other folks there. So to keep the meeting moving, I did it. Hindsight, I should have just said, I don't think we can have a meeting. We don't have 5 of us. But I didn't. We moved forward with business. So no, there was no public hearing.
Mr. President, can I please speak?
Sure.
So, when I got your guys' documents, go ahead and pass this down. This has been addressed multiple times, that zoning book is out of date. The 4-person requirement is not what's presented to the public. That and other aspects of that have routinely been called out. You guys are a body of 5. The state considers 3 to be a quorum. That said, I kind of would echo some of the sentiments and concern. I don't think this really should have been a meeting, and the reason being is, Ms. Rosso, there was a massive conflict of interest at that meeting, a massive one. And it doesn't matter how you slice it, the legal definition of conflict of interest, whether it be Black's legal dictionary or just Merriam-Webster, both identify a conflict of interest when a public official's personal interests are contrary to her loyalty, his or her loyalty to public business. And you were too close to this. You should have recused yourself. Actually, if you wanted to stop that measure, if you would have recused yourself, you wouldn't have had a quorum. You voted no on something there was a conflict of interest on. And I say that because per the Zoning Enabling Act, the act that governs the ZBA, MCL 125.3601, subsection 9, a member of the Zoning Board of Appeals may be removed by a legislative body for misfeasance, malfeasance, or nonfeasance in office upon written charges after a public hearing. A member shall disqualify himself or herself from a vote in which the member has a conflict of interest. Failure of a member to disqualify himself or herself from a vote in which the member has a conflict of interest constitutes malfeasance in office. It's clearly stated.
Can you define conflict of interest, Jamie, and how that?
I
relates?
feel like I just did. You
Could you?
have,
Because I've attempted to do that with planning stuff,
Hmm?
and you directly told me I could not.
what exactly?
On jobs, approving plans on jobs that I was bidding on? That's a
Yeah,
conflict in my mind, and you told me I had to vote.
No, I didn't. I've never told you that.
Oh, yes, you have.
No, I haven't.
Yes, you have.
What exactly?
But so then-
Because I have never done that.
Regardless of that,
I would
we go
never
back
tell you to walk into a
your-
legal
your
issue.
online- Your online that I feel is wrong, right? Because if you look at the reference and the article or the version of what zoning act or ZBA ordinances online, they are exactly what is given to us in the book.
They're not exact.
It is the same version.
It's the same version,
It's the
but there
same
is
version.
different
So unless
verbiage.
it's noted somewhere that that's been omitted, how do we know it's not just a typo? The online version is garbage. And I've
That's-
been saying that for years. It's confuddled, it's all messed up. It's almost impossible to find things sometimes. And I don't trust it. There's differences between everything that everyone's been operating out of, the book that Mark Clark's got down there, everything. So if there's an issue with what's online and compared to what has been given to everyone on these boards to operate off of, that's an issue.
I don't
So
disagree.
then everything should be halted regardless until everything's voted on, decided on, that it's the same.
The ZBA,
Regardless, was there a
Ken-
public hearing?
That's the question.
I was not there.
You were there.
I was there after. In the beginning, I showed up 15 minutes late because I was still at the office. But
So there was no. public
regardless,
Okay, you just indicated that after the public hearing, trustee Russo, but there was no public hearing.
so I guess then, yes, defer to Mr. Clark. The lack of public hearing is, are they okay with 3 as a quorum? Does the lack of public hearing negate any of this? And what is presented online versus what is a book that has not been printed in this office in the village since 2012? That's the last time those were printed. They're all upstairs. We've already identified, real quick segue, that my predecessor did not do the best job when amending things online. So therefore, what is presented to the public, you have in front of you, which one is the one that should be followed, sir?
Well, I don't mean to answer your question with a question, but that depends on what is the official ordinances of the Village of Romeo. When this matter was presented to me in the last day or so, I looked at a couple of things. One is, as Mr. Parker mentioned, the book, which I'm old school. I like to hold things and turn pages. But if I'm turning the wrong pages or pages that don't exist anymore, that doesn't help anybody. So I have to ask the question, to which I don't expect an answer, but it is a question that needs to be resolved, and that is, which are the official ordinances of the Village of Romeo? And the reason I ask that question is because in the materials that I received,
Microphone?
I try to avoid that. In the materials I received, the ordinance, ZBA ordinance, it says Article 18, Section 18, and then there are the printed materials. Well, if that's the ordinance, that's fine, and it has to be followed. But there are discrepancies between that ordinance and, again, as Mr. Parker said, the book. And so when I look at what was printed out from the book, there are,
This is the book, that's the.
well, there are differences. Well, no, what came in my package, the 18, Section 18 something, is not in the book. That's not what's in my book. Now, that could be a failure of me to update inserts over the years? I don't think so, because I do that, but nevertheless, I might have missed something. So when I look at the book, I get this printed one that says Division 46-11-2 Board of Zoning Appeals. And the reason that's important is because the two ordinances, while there are many similarities, some of the verbiage is exact, word for word, but some of the provisions are different. So somebody has to decide. I'm not prepared to decide this, and it's not my decision anyway. I believe it's the council's decision, but I'm not prepared at this meeting to say, oh, this is the version, as opposed to, no, that's the version. Because we have to see what was adopted, when it was adopted, was it amended, when it was adopted, was it properly published and noticed? If it was amended, were the amendments properly noticed and published? So I'm not prepared to say this is the one and that's not the one, but there definitely are dissimilarities between the two of them. And I don't know what action was taken at the ZBA meeting. I was not there. I don't know whether it was an interpretation of an ordinance that was taken by the building inspector or somebody of that nature, or was it for a variance? But the subject matter before the ZBA at the time matters, because the ZBA has the ability to do certain things and doesn't have the ability to do other things. So not only do you have to determine which is the applicable ordinance, the correct one, and it's not a pick and choose, like we like this one but we don't like that one. It's not that. There should be the ability to determine from the village records which is the lawful and current ordinance. Again, it's not a menu. It's not a la carte. There should be the ability to determine what this council has done prior through its actions to establish its ordinances, including the ZBA. So let me, again, I apologize for answering a question with a question, but I would like to know what the subject matter of the ZBA hearing was.
It's a use variance.
Okay, so it's a use variance, and
There was two.
There were two, yeah.
two use variances?
Or
One
the second
for
was, go ahead, sorry.
use and one for setbacks.
Setbacks.
Dimensional.
Yes.
Okay.
Two
So-
different properties.
Okay, two different properties?
Yes, two
Okay.
different locations.
Okay, so what is, in terms of the council's concern, is the concern over both of those matters or just one of them?
So for me, it's not so much the concern on the outcome of the vote, it's that it wasn't handled properly.
Yeah, how it was done.
Okay.
There was no public hearing, depending which way we're looking, there wasn't 4 members.
Okay,
There's
so-
a lot of concerns with that.
Okay, so then I revert back to me, the basic question, what has to be determined is which version of the village zoning ordinance, or the sections in the village zoning ordinance relating to the ZBA are the current enforceable provisions. That's critical. You have to determine that, because what you have before you, or at least what I have before me, they differ significantly in some very important aspects. So by way of example, when I look at the book, the ordinance book, my Bible, no disrespect intended, there is a section, 46-75, that says limitations on powers. And number 2, subsection C, number 2 says, nothing contained in this division shall empower the Board of Zoning Appeals to, and then it lists 4 things. One of them is grant a use variance. So if that's the version, then the ZBA did not have the ability to grant a use variance. But if you look at the other version, the Article 18 version, it has limitations on powers, section 18.04, and there is no prohibition on a use variance. So now let's digress, or at least go to, as some people say, original principles. If you look at, and I believe Mr. Lucero made mention of this, if you look at Michigan Compiled Law, Section 125.3604, Zoning Board of Appeals. You don't need to wallow in the entirety of that statute, but a couple of things come forward that I think inform inform the position in which you may be tonight and then going forward. One of them is Section 8, the Zoning Board of Appeals of all local units of government shall have the authority to grant non-use variances relating to the construction, and it identifies them. And then it says, the authority to grant variances from uses of land is limited to the following: cities and villages. So the village does have the ability to grant use variances, but if you haven't exercised that ability in your ordinances, then you don't. So if you take the Section 18 version, you can grant the use variances. If you take the 46-75, you can't. And then regarding the number of people, which is also very critical, as was mentioned, the ZBA should have 5 members and 2 alternates, and a quorum of 5 is 3. But there's a supermajority requirement in the statute, and I believe it may be in your ordinance as well, but let's just for the moment rely on the statute. And it says, the authority granted under subsection 9, which is the one I read to you a moment ago about the authority to grant use variances, is subject to the zoning ordinance of the local unit of government, otherwise being in compliance with subsection 7. And I'll tell you what 7 says, but let's follow the progress. So does the village have the ability to grant use variances? The answer is yes. The question then becomes, does the village in its ordinances allow for the granting of use variances? And the answer is, I'm clueless. I don't know. And so then the question becomes, if we meet the compliance with subsection 7 as having ordinance provision that requires a 2/3 vote. So let's go back to section 7 of the statute, not the ordinance, that says that if you're going to grant a use variance, you have to have a 2/3 majority. So 2/3 of, you can have a quorum, but that doesn't mean you have 2/3 of the ZBA. It would require 4 members. 3/5 is not 2/3. I'm not good at math. In fact, I'm probably mathematically illiterate, but 3/5 is not 2/3. So again, I segue back to this is, to be kind, it's murky, and to me, and my advice is to first determine which ordinance is the valid, operable, enforceable ordinance in the village. And from that, you can then either walk it back or analyze. And when I say walk it back, I don't mean unravel it. I don't mean to change things. But you can go back to the start. Okay, here's the ordinance that is applies. And so now we're going to apply that ordinance to the facts. But until it's determined which ordinance is the adopted, enforceable, valid ordinance, any advice I would give you or any decision I would recommend about 2/3, 4 votes, 3 votes, quorum is, it's not irrelevant, but you need to have the proper ordinance to apply to the facts and analyze those facts.
Thank you, Mr. Clark.
Mr. President, if I could, real quick. There are 3 other zoning amendments. 482 is the ordinance, but there's also 483, 484, and 485. None of them are listed on the website anywhere. One of them states that it amended parts of zoning board when I looked at the database at the office. But the problem is, and it has always been, in this village, the retention of records is not the best. We don't have many ordinances under, say, 515. We're now at 572. So we're missing hundreds of ordinances. That may be in there as well. Now, 43, 484, and 485 were passed respectively in later 2000 and throughout 2001 because Mr. Lee and Ms. McLaughlin actually had a good record of saying when they were passed, but can't find where they are. We have meeting minutes upstairs somewhere of those. We have meeting packets of those, which I certainly can try to dig out. They're behind a mountain of stuff, but that further throws a wrench in things. And when we're talking about zoning, there was an issue once with Mr. Bomarito, where we spoke to Mr. Parker about a shed. In that book, it says the shed, I think in CBD, needs to be covered, right? Like in a fence line or something like that. But online, it doesn't.
It's clearance from buildings and,
Yeah, but online, it doesn't at all.
yeah.
Now, online, you can go right to your property line with it. And
I'm not
it's-
gonna deny that there's discrepancies. We all know there's discrepancies. And normally it's Megan's, that's all I know.
So the bottom line is that we need to come up with one ZBA ordinance that we can stick to and
I wouldn't even
use.
say ZBA in general. I think
I've-
all our
I've-
ordinances across the board.
Well, but this one in particular,
They need to be updated.
updated. So who are the other two members? Who are the two?
Dante
Dante
Leo
Leo
and Robert Seggy. But can I ask one more thing of Mr. Clark? Since it was asked. Mr. Clark, can you define what conflict of interest is?
Well, the conflict of interest is, I think, it's kind of like the Supreme Court said many, many years ago in trying to define pornography. I can't define it, but I know it when I see it. And so the answer is some conflicts of interest are more obvious. That I'm voting on something because I'm going to receive financial remuneration for that. Some are more obvious, some less so. So I don't want to just blurt out kind of a general or blanket definition of what conflict of interest is. I would rather know what the facts are that arise to a question of conflict of interest, and then be able to apply those principles to those facts. And so, again, the obvious one is if there's a direct financial benefit. Others are more subtle. Sometimes it's, I live next door to the person who wants the variance or wants the planning commission approval for a site plan. Some are, again, more subtle or maybe more nuanced. But what was, in fact, in one of your ordinances, again, depending on which version, if you look at the published one in your ordinance book, 46-71, subsection C, it talks about members of the Board of Zoning Appeals shall be removable by the village council for non-performance of duty, so they don't show up at meeting after meeting. There could be an issue there. Or misconduct in office upon written charges and after public hearing. So if somebody's being accused of misconduct in office, they need to be informed in writing of what the claimed misconduct is, and they're entitled to a public hearing on those charges. A member, and this is mandatory, shall disqualify himself from a vote in which he has, this shows how old it is, because normally it says he, she, but in any event, which he has a conflict of interest. Failure of a member to disqualify himself from a vote in which he has a conflict of interest may, not necessarily, but may constitute misconduct in office. So I'm not dodging the question, but I don't want to throw out just general principles of conflict of interest. I would like to know what the facts are. Facts are important. They're difficult things sometimes, but they're important.
Trustee Russo.
Okay, so I got as
Is
far
your
as
pro-
Dante Liu. Who's the third one?
Excuse me,
And
Mr.
who?
Chair.
So Shelley and Dante and who?
Robert?
Robert Segi.
Mr. Chair, I'd like to ask Trustee Russo a question, please. Does your property butt up anyway to this Bailey Street property?
I don't even think that's fair to have her answer that right now.
Well,
We're talking about specifics from a meeting that already happened.
Well,
We're here to discuss the zoning.
right, but
ordinance.
he just brought up a conflict of interest, that's all I'm asking.
So let me clarify. No, it doesn't butt up, and neither does the other one who wanted the housing variance for their
Okay. that's all I
setbacks. Neither property do. But everyone's alluding, I'm sure, to the Bailey one because I live on Bailey. However, this
That's not
meeting has
conflict.
nothing to do with that. Obviously, we have some serious issues in our zoning ordinances and what we're doing. And regardless of what happened then, we cannot operate, we can't have another ZBA meeting until we get this straight. So let's stay focused on what this true issue is, protecting the village and getting it straight. It has nothing to do with those votes and what happened, nothing.
Okay, I have another question. The board is made up of 5 members. Is it I heard somebody from the planning commission is supposed to be on it?
Yeah, so I found that it's right in the first page, Article 18. I'm not gonna turn this on, 'cause I think this is the one.
That's correct, and since Andrew and Mitt have both stepped off, that seat has not been filled on the ZBA.
Right, so it's obviously a big issue that we need to at least fill the 2 seats first and foremost, and then we have to determine what the proper record is. I mean, to me, not to be too harsh, those are the only 2 things that are really relevant tonight. I don't see why this
I
isn't
agree.
being discussed. There's nothing time sensitive about it. I don't see why we're here right now. To me, it's
I'm gonna argue the time sensitive, because you have people that are moving forward with the project that potentially is moving forward because, from a meeting that was not valid.
the village council isn't empowered to do anything about it. We can have Mark write a letter to recommend that they review it, or it can go to the Romeo Circuit Court, but there's nothing,
If
this
the meeting was
board-
not valid,
it doesn't matter.
I'm not
It
talking about the
already
vote.
happened.
I'm talking about the meeting being valid, period. Mark, can you weigh in on that?
Well,
Because there was no public hearing.
Well, let me just say that ordinances and meetings and actions taken by the council, the planning commission, the ZBA, they're presumed valid. Things that are done are presumed to be valid unless they are proven to be otherwise. And so then the question becomes, and I'm not sure I have a clear answer, but I'll try to give you some guidance. The question becomes, well, what do you do? Because under both versions of your ZBA ordinance, and again, I don't know which one is appropriate, this gives me great pause, but under both versions, an appeal is to the Macomb County Circuit Court. And so I'm not sure my feeling is probably stronger than not sure. I share Mr. Kerr's concern that you can't just administratively say, well, yeah, you met, you had a quorum, you took this action, and no good. Or this version of the ordinance applies, and maybe you can shoehorn it in. Somebody needs to challenge it, and the review process provided both in the statute that governs ZBAs and in your ordinance is not, there's no appeal process to the planning commission, there's no appeal process to the village council. The appeal process is to the Macomb County Circuit Court. So if somebody is aggrieved, I think, at least my initial reaction tonight is that you would have to file a complaint in the Macomb County Circuit Court and say the action that was taken is not just voidable, but it's void because, and then you would recite the facts why, so that it was, the decision is invalidated from the beginning. My pause among many is that which ordinance are you going to appeal under? you have to determine which ordinance is the enforceable ordinance in the village. I apologize for repeating myself, but we're a little bit like people wrestling on the deck of the Titanic. And until you know which ordinance is enforceable, it doesn't really matter, because we're talking about things that may be on parallel tracks and may never cross.
So I want to follow up on one of the remarks you made. The appeal would only be introduced by the applicant. We're not going to
Typically-
appeal our own decision as a village board.
Typically, that is the case, that the aggrieved party is usually the person who, the individual, the property owner who feels adversely affected. But, and I haven't looked at this, so I'm not prepared to wax intellectually about this, but there has been some change in the law within the last few years, either court interpretation, that does allow certain entities, municipal entities, to be the aggrieved party. Whether this is one of those instances, I can't say. I don't know. I haven't looked at that. But yes, to your point, typically you wouldn't appeal or ask for a rescission of a decision of your own body. That is very unusual. Not unheard of, I guess, but it's unusual.
So both items that night, sorry Shelley, I'll stop talking after this. Both items that night at ZBA were in the affirmative to the applicant, right?
Yes. they were.
Because I could see where there'd be a big issue if something was denied and we weren't procedurally operating as we need to be.
And again, that's not why we're here tonight. It has nothing to do with those two applicants or what we think they might or might not do.
So then why
It's
is
be-
it time sensitive? Because that was.
Because-
That's what I said, because if the meeting was not valid, you have people moving forward with projects and putting money into things that they potentially would get reversed.
Absolutely.
But now that it's valid, until proven otherwise.
And there could be another ZBA meeting called. And so we can't have another meeting if we don't have this straightened out. So without knowing how soon or how long, we can't, I'm very confident we should not be having another meeting until we
I
can move
agree.
this along. But also, yes, those business owners are doing what they need to do, and without knowing whether we were in the right or wrong, it's not fair to them if we were wrong and Mark said, we have to stop.
But it was
So-
in the affirmative. Both applicants are happy. So the only person that would be in a time-sensitive situation is somebody who's upset by the decision.
No,
Not if it was deemed that it was wrong and it wasn't valid, then they would be pissed off because they put money into something that they might be told now, you
The
have to
only
stop.
reason you'd the only reason you'd rush to prove the meeting invalid is because you're upset with one of the two decisions that were made that
I'm not
night.
trying to prove it invalid. I don't
I
care
think-
about
I
that
think you're
meeting.
so narrow-minded right now, you're not trying to open up and think that
Thanks.
maybe someone is thinking about the
Well,
applicant right now.
We're not going to
And
be
their
able to.
applicant's happy.
financial well-being.
The applicant's excited.
But let me-
Wonderful.
You're missing the
For-
point.
I don't-
Forget about the other two applicants. This has nothing,
I don't want to get involved in the debate, but I feel constrained. I must say this, that you really are hard pressed to try to put the toothpaste back in the tube. The decision has been made, the meeting was called, it proceeded, and I think that if you went back to the applicant, and again, I don't know, this, could be an annuity for me as far as I know, but if you went back to the applicant and said, oh, we've decided we were operating under the wrong ordinance, and we, now, we're gonna say that, you don't get your variance, I think if the applicant sued, that the village would be hard-pressed to be successful in that litigation. Because the important consideration on both sides is due process. And due process, very simply defined, is notice and an opportunity to be heard. So the applicant submits his materials or her, but these items are presented. the ZBA meets thinking that, yes, we're doing what we do and we're doing it properly. Presentations were made or questions were asked. I don't know what happened. I wasn't there. But the ZBA then makes a decision, and which, again, until proven otherwise, is considered valid. So now if I'm reading the tea leaves correctly, the thought might be, we got to go back to this guy and tell him, no, he can't do this. I strongly recommend you don't do that, at least not right now, because I think he was afforded due process, he was afforded what he thought he should receive under the ordinances, and he got that, and now you're gonna say, oh, you weren't wrong, we were wrong, so now you don't have it. I would caution strongly against that.
Sure.
I have a question, Mark, because we've ran into this at the building department before where permits had been signed off on by someone who had no ability to do that, and it was always told to me by one of our building inspectors that it falls under quality, some sort of qualified immunity at the time. You thought you could, therefore it's kind of hard to undo. With something like that,
I'm not prepared to say that. I'm not prepared to agree with that. The example you're providing, I can see where that would happen, but the comparisons I don't think match, or the contrasts I don't think match. And so that would not be my point of analysis, that we've kind of put the genie back in the bottle in the building department, so we're gonna try to do the same thing with the ZBA. I'm not gonna encourage a walk down that path.
right, no, what I was saying is, even though they may have unknowingly, may have not violated an ordinance, they passed it, if it was trying to be invalidated, would it still stand, is what?
Well, who's
that
trying to
was-
invalidate it? That's,
Right.
again, that's kind of, I'm
So-
gonna date myself, but that's the $64,000 question.
Well, we're obviously not gonna be able to figure this all out tonight, and since we can't get it on the agenda for Monday's night meeting, let's just plan on putting it on the agenda for the following month, so that we can get to the bottom of this.
So Mark, can you give us some guidance at all on how we should look at which ordinance?
Yes,
Like-
I would go back through the village records and find out there should be a chronological, if not subject matter, line as to the ordinances. I don't know how they're organized in the village. I know how mine are in the book, but you should be able, and sometimes you start at current circumstances and walk backwards, but you should be able to follow a line from the adoption of the ordinance, the one in I believe the ordinance in the book was adopted in 2000. And so you should be able, and again, it may be more complicated than this, but the ordinance that's in the book says it was adopted on July 17th of 2000. And so I would think if you went back to that point in time and worked your way forward, you would find out whether this 18.00, the section 18, was ever adopted, or was it before the year 2000, and just figure it out.
So regardless of what one was used, if it was 18, it clearly states 4 members are needed. But you said if we go to the 46, it doesn't state a number, but it does say it references the 2/3. So
No, the statute to which I made reference mentions the 2/3. So my point is, if I understand your question or where you're going with it correctly, is let's say that the July 2000 ordinance is the applicable ordinance. It's the one that's in force. Well, under the state statute that provides for ZBAs, that ordinance appears, I'm not going to say conclusively, but it appears that it does not comply with that two-thirds requirement because it's not in the ordinance.
Okay, so moving forward, it sounds like we need to figure out chronologically what ordinances are accurate and get those to the ZBA members. We need to appoint at least 2 others and get some alternates, and have no ZBA meetings until we get this resolved. Does
I
that
agree
sound
with,
like a clear?
I agree with that. I don't think, because the questions have been raised, I don't think it would be in the village's best interest to conduct immediately in the future ZBA meetings with 3 members. And also particularly if if the request or one of them is for a use variance, because one version of your ordinance permits it, another version doesn't. And the voting requirements dictated by the statute say if you're gonna have a use variance, which you're allowed to do, the voting requirement is 2/3. So yes, you have to, it's, I guess, a little bit like a Rubik's Cube, but you gotta get all the colors to match.
Okay.
So, I think,
Maybe I missed it. So you said if, because I know the 18 says it's special land use, but you said the 46, the ZBA can't do usage, period.
Yeah, correct. It says in 46-75, the limitation on powers, and this is from the July 2000 ordinance, it says, nothing contained in this division shall empower the Board of Zoning Appeals to, TO, and then it lists 4 things, and one of them is grant a use variance. So, under that 46-75 provision, there's no ability on the part of the village to grant a use variance. Now, the law permits it, and in 1804, you could, yes, in 1804, section 1804, you could grant a use variance, the ZBA could, because it's not listed as a limitation on the power. And the statute, the enabling statute permits it. That's why it's so important to know which ordinance is valid and enforceable. Otherwise, you're making it up as you go along, and I strongly recommend against that.
thank you. So I think we obviously got our work cut out for us to get this squared away. We can't get it done tonight. Been some good discussion, a little bit of learning going on. And so moving along, is there any second public comment, people? Any?
Do we need some type of official motion or movement to halt zoning?
No, because I think under, again, depending on your ordinance, the 46, the one that starts with section 46, the ZBA meetings, I believe, all meetings of the Board of Zoning Appeals shall be held at the call of the village clerk. So Mr. Lucero can just say, we're not having any ZBA meetings. He has the ability under the ordinance to do that.
A couple of years ago, they did a standing second Wednesday, but we keep that as, if something comes in, then we tell people, like if it's on the 3rd Wednesday, you gotta wait 2 weeks. I was able to find also an Excel spreadsheet, but I don't have access to the server where the updated one is. But yeah, to go back, those zoning ordinance amendments were 6/18/2001 and 9/17/2001. And like I said, we don't have them. So I would invite all of you guys to come and help me dig through the upstairs, because it's a monumental task.
And for what it's worth, I'll just mention, under either version of your ZBA ordinance provisions, they both say, if you get any comfort out of this, they both say that the ZBA meetings will be held at the call of the clerk. So Mr. Lucero can simply say, if somebody applies for a hearing or petitions for a hearing, can say, no, we're not able at this point to do that. So, I mean, you can pass a motion or offer a motion and vote on it. I don't think it's necessary, but certainly you can do that.
Does an applicant, because the next highest appeals court has jurisdiction, would an applicant have to go to the county for any issues, or they just couldn't have their appeal, or their application heard?
So, excellent question, and the answer is, my default orientation of due process. So if somebody has an issue they want brought before the ZBA, and you can say, well, okay, we don't have the ability to call one right now, well, that might be okay for a week or 2 weeks or a month, but at some point, I suggest the earlier the better, at some point, you need to know whether you're afoot or horseback. You have to find out, because at some point, you will be depriving somebody of due process. Look, I need a decision on whether it's a dimensional variance or a use variance, and if, if you delay 6 months, a year, 2 years, whatever it is, at some point, people are gonna be deprived of their due process. And that's not a magic number, it's not a week, it's not 2 weeks, but there is some, I would approach this with dispatch. I would try to figure out as early as you can what ordinance applies, and then conduct yourselves according to the applicable ordinance.
Who reviews the applications when they come in before they even get to the ZBA?
Myself, Sarah, and then Miss Livier, our planner.
So unless someone wants to make a motion or feels compelled to make a motion, let's go wrap up this discussion and move on.
I make a motion that we pause ZBA meetings until we have resolved and confirmed which ZBA ordinance book that we are following.
I'm sorry, what was it? That was like the, I just want to make sure I got everything.
That
Pause,
we're
ZBA
pausing
meetings.
Until we resolve which ordinance book we are using. And
Does
that
that
we
also
have a full
include
board. Pardon me?
Does that also include the addition of applicants to the board? Because we only got 3. You need to get to 5, right?
We
We'll
need to
have
get
we'll
to
have
5 and
fix all
2.
that.
Are you still a alternate? I thought you were on the roll as an
Can't have 2
alternate.
trustees and.
No, you have to have 2 alternating trustees, it says that. They can't be
Yeah.
there at the same meeting, but they can alternate. So someone on the board of trustees has to be an alternate.
I never, no. Bottom line, no.
Okay.
If my name's there, I don't know why it's there.
All right, so we have to find 2 alternates too.
And make someone from planning commission start sitting on that board
Pardon
as
me?
well. And we have to pick someone from planning commission to sit on it.
Yes.
Yeah, do you mind this being added to your proposal, trustee Russo?
Okay, so I make a motion that we halt all ZBA meetings until we have a full board, alternates, the designated book that we are using, and a representative from planning.
Second.
So before we vote on that, my last piece of discussion, obviously, the glaring concern is which ordinance is applicable. But with 3 members, there still is business you can conduct. You just can't do anything with that would require the supermajority, like a use variance. If all 3 of you were to vote yes on something that only requires a majority of the 3/5 of the board, you still can conduct business.
No, because
So
we
that's-
don't know what our rules are.
That doesn't mean you can't conduct business, you just have to figure out which rules are applicable.
But if you're in the other one, it says you need 4. It's clearly stated.
4 is for use variances, that's
And the-
not
and
for
the-
all and every vote.
And the 18,
Get
it
legal
clearly
with
says you need 4.
Yeah.
Mr. Clark?
I agree with Mr. Kerr as it relates to the ability to conduct business. So by way of example, unless 18 requires 4 at every meeting, and I have not, you probably don't want to watch me read, but in any event, let's assume that a quorum is enough to decide a dimensional variance, that it does not require 2/3, and that's true in both versions of the ordinance. you could conduct that business. And one of the things I'll say in the section 18 is in section 18.01, subsection 2, it talks about the board shall not conduct business unless a majority of its members are present. So if it's a board of 5 and you had 3 members present, you could conduct the business.
What is 1804-1 reference?
Well, I don't know. I'll take a look.
Just so we're clear while he's looking that up, Shelley, you're saying a prohibition on all meetings, correct? Regardless if it's 3 or the 4, all meetings.
Until further notice.
Yes,
Until further
because we-
notice.
yes, because we don't know how many,
Yeah, because it's not just the members that are in question,
Right.
it's
what
A lot
can
of
we do and
different
can't
things.
So we
do.
got a lot to hash out on this
Yeah.
and get it figured out.
Yeah.
well, the state
And
says
they
you
don't-
can have a 2/3
Yeah.
or
And-
3/5. Our ordinance says you can't do usage. So
Right.
depending on which one you're looking at.
It does,
In both ordinances, it's that the 3/5, or excuse me, the 2/3 or 4 members is in reference to use variances. You can still do
No.
dimensional variances in your regular everyday housekeeping business.
This
If you
says-
just have a quorum or a board majority.
No,
so you do have.
This is any action.
You do have a conflict. Let's really have some fun tonight. I mean,
Yeah.
it's Thursday night.
I just want to
So-
clarify, I just,
there.
So let's really have some fun. If you look at section in the 18, section 18.01, I read to you, the board shall not conduct business unless a majority of its members are present. That to me indicates you need to have 3. But as Mr. Parker mentioned, if you look at section 18.04, subsection 1, it says the concurring vote of 4 members of the board shall be necessary to approve any action of the board, modification, interpretation, or appeal stated under, or stated in, and then it refers to section 18.021, which is ordinance interpretation, and 18.02.2, which is appeals of administrative decisions. And so, if we really get into the weeds, I will say that you could grant a non-use dimensional variance with 3 members, because that's not recited in the provision that requires 4.
Okay, which is all the more reason we need to
Yeah, we need to clear it up.
get it all cleared up and have one ZBA set of rules that we go by. So we have a motion on the floor by trustee Rosso, supported by trustee Fowler.
Well, so when, I'm assuming Jamie's you're gonna work on this, get it together, and then should this come back before the board?
I mean, I'm gonna try, like I said, I have
You got time by Monday.
I have a,
Certainly put it on our next agenda.
I have spreadsheets that say what they are, but I've been searching for ordinances. I mean, I even went to Mark's office a few times to see if he may have written any of the ordinances that I had been trying to find. So, I mean, I'm
Might be at
not,
a point where we put it together and
Yeah.
we have to adopt a new version of this.
yeah, I mean, that might be, I mean,
Clark's help?
2000, I mean, we're talking 25 years, a lot has changed. You're in trades, a lot has changed in 25 years. It's probably time that gets updated, because I think, looking at this, let me see real quick, because I think there's a zoning ordinance amendment in 99, and then there was a zoning ordinance full rehaul in the mid-'80s. I found those in the '70s and in the '60s.
We know the
So-
2000 version was adopted.
Yeah.
right? It was printed in the.
Well, no,
books.
what I'm saying is, they have gone back over the years. So it's probably time, you guys.
So could, Clerk
Look at
Lucero,
it.
could you please reread your motion from?
And if I got it wrong, just
Well,
tell
fix it
me.
now.
Yeah. Halt all ZBA meetings until there is a full board with alternates and the zoning ordinance discrepancies are resolved.
The halting, the members being appointed, that we have adopted a zoning ordinance book, guidelines, and that we have a planning member on the board. And those are all the things we need to comply with our
I
ordinance.
think that last one is,
Part of the full board.
yeah, that's just part of full
Okay,
board.
that's fine,
Yeah.
full board.
So a lot to work on until we get this taken care of, but all in favor?
Aye.
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 Opposed.
So we have 5
Fowler, Bartholomew, Parker,
in
and Russell
favor.
in favor.
and Kara opposed.
Motion to adjourn.
A public comment.
Oh, wait a minute.
Oh, public comment, sorry.
Want to set it up for you guys to have another opportunity to get up for public comment, so if you do, right now would be the time. Janice, hi.
Still not used to that.
We'll get an alleyway there for next time.
Megan was saying someone pushed it over here. We were talking about that.
Okay, I'll make it quick.
Just your
Janice
name and
Fowler.
address. Yeah, thank you.
I live at 319 Dickinson. I am Chair of the Planning Commission. I just had one comment and then one question. It might just be for Clerk Lucero with regards to Planning Commission. The comment is just the zoning ordinance book 482, the 2000 edition. This is the one that's given to all planning members. This is the one that we have. It's the one that we operate from. I know there's the online. I did do a little digging into some of the online things, and a lot of the references that are on the online reference this book, and there's no amendments behind it. It just says, this is your reference. So, yes, I just want to make sure we clarify that. You know, I will go to the online to look at things, to compare them, but this is still the one that we mostly are
And
using.
if you have a
there, too.
question for Clerk Lucero, if you could do that like after the meeting,
But
because this
it
is only
is,
time for
but it
comment.
might be, it's related to, these updates. I guess my concern is, if we're saying we're halting ZBA things to look at ordinances, but we are using this book, how is that gonna affect planning? Because planning uses this ordinance book to make decisions, and if we don't know what ordinance books we're using, is that gonna affect? I guess my question for Clerk Lucero was just, do we know in those updates, is it just ZBA updates, or are these things that are gonna affect planning as well? I guess that's the question. And if that doesn't have to be answered now, I'm just trying to be proactive for the December meeting of planning. If we know this is going to be a problem because we may or may not have conflicts with which one of these we're using, if that is gonna impact planning meetings at all, or any of the,
If you don't mind, if I could just real quick,
Sure.
maybe add it to our agenda, we can have a discussion at the planning table on
Okay.
this topic and make a decision as a planning commission, how we feel we need to move forward with, maybe if it's special land use or whatever approvals we may have a conflict with the book.
The problem is, so, I mean, I know we're not supposed to talk back and forth, but you opened the door, so I'll take it.
We've already
too.
broken the rules, go ahead.
Invariably, it's going to affect you guys.
Mm-hmm.
The problem is, and I'm sure this would be something to have legal ask as well. I had spoke about how I had restructured our code of ordinances, and I was waiting on a few other ordinances to come in. And now, before I ordered new books, and now it looks as though we should probably look at this. The bigger issue, though, for me, is what is presented to the public versus what is not openly available to the public, because now you have two sets of rules. And I don't think, and I could be wrong, and Mr. Clark could check me on this, aside from the Board of Trustees, ZBA is the only other board that has the power to interpret. So you guys can't really do what you were suggesting, Justin, and kind of pick and choose or decide if you're gonna agree with the book or not. I think you have to go forward with a set of rules.
More of a discussion, and
Okay.
obviously, we make recommendations, right?
Mhm.
Back to the board, so if it's a discussion we had, And if we had to, I'll say postpone, not table.
I'm sorry, I was
topics.
looking at it in the
Yeah.
lens
I
of
understand
someone
what you're
came.
saying. I'm not saying
came to you.
we're gonna pick and choose.
Yeah.
I'm saying a discussion maybe needs to be had if.
So I'm gonna rein this back into public comment only. Thank you.
Thank you.
Anyone else?
Thank you, Chair.
Okay, so as you've said, these ordinances have been in question for some time. So I'm still baffled why you're having a special meeting when you have a regular meeting on Monday. This is not something that was a hot topic that needed to be addressed tonight. There was no way you were going to figure this out tonight. There was no way that anything was gonna change, except that you wanted that meeting nullified. That is the only outcome that you wanted from this meeting. Otherwise, there's no reason to have this meeting. So, once again, I'm going to say that this was a colossal waste of the taxpayer dollars, and I'm gonna ask that you do not accept your meeting pay. I have never seen a developer act in 3 days. So if you really thought it was an issue, you could have notified the clerk immediately and said, gosh, I really think we screwed up and we shouldn't have had that meeting. Can you please investigate? Mr. Clark could have looked at the law and given a legal opinion and said, we're all sitting here and we're gonna have to pay you for this. It was a waste of time.
Thank you. Anyone else?
Motion to adjourn?
Trustee Fowler? Support? Motion made by trustee Fowler to adjourn, support by Bartholomew. All in favor?
Aye.
Any opposed? Thank you, everyone.